Okay, so hello everybody. Welcome you once more to my lecture named Chinese Green Law. First of all, I would like to tell you something about me, so I would like to introduce myself. My name is René Bernard. I'm a Canfa, so a student in his final semester at the moment. My major is sinology. I have two minors, public law, in which I have already graduated, and political sciences. Currently I'm writing my MA thesis about the Chinese bar with a special focus on Weiquan lawyering. My main interest is Chinese law and politics, especially constitutional law, rights defense, lawyering, environmental legal issues, and Chinese foreign policy. And if you want to contact me, ask me questions or so, you can find me on Facebook or write me an email. Okay, so let's get started with my lecture. Exactly 1 month ago, an important conference had been held in Mülheim, Germany, which once more proved the actuality of Chinese environmental law and policy implementation. This conference, named Implementation of Environmental Policies in Urban and Rural China, its successes, problems and deficiencies, was headed by Professor Thomas Heberer and Professor Dieter Grunow, both of University of Duisburg-Essen, and marked the end of a 4-year research period about the implementation of environmental protection mechanisms in China. Besides these two professors, other experts like Professor Andreas Oberheitmann, who will be here in exactly 1 week, and even Chinese researchers in the field took part and discussed issues like, for instance, ecological rights and ecological justice, or public participation in eco-civilization construction. I unfortunately could not participate in this conference, since at the same time the China Week of the German-Chinese Year of Science took place in Würzburg. Since this topic is also part of my master's thesis, I've done some research by my own, and I would like to tell you my results right now. Okay, so first let's have a look at the structure. It's generally divided into 2 parts, so substance. In this part I will talk about the environmental legal regime, so we'll start with the definition. A first historical part, so the time until 1979. A second historical part after 79, and sum up the current state of affairs. In the second main part I will show you the enforcement aspect, so what strategies for access to justice exist, and this part is once more divided in a prevention and control part. So in this part I will talk about public participation, NGOs and environmental impact assessment, this Treble Simultaneity-Principle, and in a second part I will talk about the cure and liability aspect, so the repression regime, so when the damage is already done. In this part I will talk about mediation, courts, legal aid, and then give a concrete case study, and finally talk about the media aspect. This point 2.2.6 I will leave out because it would have taken another half an hour, but I'm right now producing another YouTube video which I will put online during the next 2 weeks, so you can watch it if you want to. And finally I will sum up my lecture in a conclusion. This point 4 I've also left out because of a lack of time. Okay, so let's get started with the first part, substance. Okay, I want to start with a definition, as I told you. And before I start with a definition about environmental law, I would like to tell you something generally about law. So what is actually law? There's a general distinction between so-called objective law, objektives Recht, Canfa, and subjective law, subjektives Recht, or Li. So on the one side we have this what is called objective law, and this means simply the total body of laws, regulations, norms, and other norms that exist. And on the other side we have this this kind of law which is called subjective law. So these are actually rights, so rights that everyone has. And there's of course another distinction between so-called absolute rights and relative rights. So for instance, if you and you make a contract together about, for instance, selling your TV, then you have the right to gain some money from him. But of course, Mr. Alperman here is not part of this contract, so he has not that right. So this is called also subjective right. It's only the right of you as a subject. So this is one main distinction in law. And another important issue is what I've called here 3 systems of order. The first system is what is called law, 法律. The second one, morality, 德. And the third one, custom, so 习惯, 风俗. So why do I tell you this? Because in the West we generally have a strict separation of law and morality, as well as of law and customs. This is called thesis of separation, Trennungsthese in German. And in China we don't have this strict separation between both systems. In China even today we have often a mix-up of both concepts. So with respect to today's legal system, Ma Xiaoying and Leonard Ortolano say in this book here, which is called Environmental Regulations in China, and which is one of the most important books with respect to environmental law, say, for instance, for formal rules, so what is generally law, they define formal rules as, citation, pollution control requirements detailed in laws and regulations. And they define informal rules, so what is the morality aspect and the custom aspect. They define this as, citation, derived from customs and unwritten codes of conduct that affect how environmental laws are implemented. So you see that this still works today and is an important distinction, as I will also show during my lecture. Okay, this slide I leave out. And right now we can ask, what is then environmental law? A definition which you can see quite often is the law that protects the environment. So it's actually environment protection law, Umweltschutzrecht, 环境保护法. This might seem very natural for us today, but in the history of the PRC, environmental law was not always environment protection law. Because during the Mao era, the environmental law, the aim of the environmental law was not to protect the environment as an end of itself, but rather it was the aim of helping to build up a socialist economy. So this is very important, that the environment is today an end of itself. And just to give you another definition, I've chosen here a definition of the 中国大百科全书. It's a main encyclopedia in China, and this definition reads, it's environmental law is the embodiment of legal norms which regulate such societal relations that result from the protection of the environment and natural resources.